faces are still around, you know?
I remember Bork getting really frustrated at one point, saying, you know, I feel like, I
So
don't
with,
want the job anymore.
with domestic violence and child welfare, one of the most interesting issues, you know, can be tragic and whatnot, has to do with children not being directly physically abused by the parents, okay? But what kind of influence on the children there is when there's domestic violence in the household. One of the only cases that is pertinent that I gave you is actually the Bond case, which is a probate and family court case. Actually, let's just start with that case.
There's a statute in there, isn't it, that says that,
Exactly. Let's start with Vaughn, and if somebody could just, and I think and this is one case in terms of us discussing domestic violence and the implications all over the place that it has, that the facts of this case are particularly important. Brooke, do you want to start?
Sure, because I passed last time, so
Okay, all right, all right.
Well, do you want me to start with the ruling?
No, in this case, I'd like to hear the facts first, the story. Let's hear the story of this household.
Basically, there was a woman, Leslie, who had 2 young children. She had been divorced twice. She was abused as a child, had 2 previous abusive relationships. And she met up with, I forget his name, the father of her next child. They lived together. The relationship was abusive, but what I found...
Well, hold on a second, because you said the relationship was abusive. Use some facts from the record that the SJC had.
Okay, well, the man's name was Ross, I'm sorry. And it seems that he was very controlling of her and abused her, and I can't think of an actual fact.
So take the words "he abused her" out of it, and instead use some.
He hit her in front of the children.
Ross hit her in front of the children.
He also, she had a daughter, and when she was a teenager, he kissed her and touched her inappropriately.
Okay.
On the mouth.
Mm-hmm.
And so they said that was sexually abusive on the daughter, and I think that's it for, other than just the controlling aspects and stuff.
So what facts depict control? You said control.
I guess the neighbor said that he controlled like where she was allowed to walk.
Okay.
Unless I'm getting that confused with other things. I think
Unless you're what?
Unless I'm getting that confused with the guardian ad litem report.
Okay.
I don't know.
What did the guardian ad litem say, and in what? The other.
Yeah.
Oh, not the case. Okay. All right.
But they were both heavy drinkers, and the thing that I found that the court just didn't seem to address was she was also abusive.
Okay.
She was sexually explicit in front of the children and abused him just by belittling him, being naked in front of the child and saying it said gross sexual things. And from what I read, it seems like she hit him because it said that she hurt him. So it just doesn't seem like the SJC addressed what she did at all, you know? It just seems to me like it was a volatile relationship where 2 drinkers both were attacking each other, you know what I mean? But maybe I misread it.
Anybody want to add some more facts? Just facts, the story itself, the relationship, where they lived, who the parties. Yeah.
Well, I think even going beyond the current relationship, I think it's important if we're looking at the relationship, at the effects it has on people, the fact that the wife was also abused as a child and had been abused in the previous 2 marriages also.
All right.
And they make the point to say that if that's the case, then somebody's either going to more than likely turn out to be a batterer or a victim.
Where did they live? Where did they work? Describe.
They eventually they moved in Nantucket, right?
Mm-hmm.
Eventually, so it's an isolated situation. Obviously, Nantucket is a smaller island, know a lot of people. She worked as a school real estate person.
And then she worked
was
as a
a
bartender.
marine guy, but he wasn't too successful.
I'm sorry, what?
He was a marine engineer at the time, but he was not working then. He was doing some carpentry or something.
Yeah. He,
Kerry?
yeah, he, excuse me, in the beginning, before they moved to Nantucket, he was doing like odd jobs and stuff. She was a real estate broker up there, but, before they moved to Nantucket too, but wasn't, as successful as when they moved to Nantucket. She was making like over $100,000 a year when they moved to Nantucket, and he wasn't really making much money at all. But there was a report where he had like knocked her out once so hard that she was unconscious, like they had to send her by ambulance.
Okay.
I guess they describe like the stature of each of them, like
Okay.
his size compared to her size. He just had a lot of like, he had a lot of like rage, like, and violent, like, outbursts all the time. He sought psychiatric help, but, they didn't stop, and then he was on lithium at one point, and the lithium, he decided to not take it, so obviously his behaviors continued, and he used physical force when with their child, so she has 2 kids in a previous marriage, and then they had Vaughn together.
Okay, so let's now talk about Vaughn. How old was Vaughn at the time of this story?
I think 5, if I'm not mistaken.
I thought he was 11.
Was he at this? Oh, maybe I'm thinking of they talked about him when he was 5.
Yes, tell the story.
All right, so
About
when they
Vaughn.
were right, so he was born with them, and the father would play rough with him, but use physical force with him, cuffing, pushing, knocking, poking. I guess he also lost his temper a lot with them, and everybody else in the household. In addition, as Brooke pointed out, he was inappropriate with Leslie's daughter, but all of this a lot of it was in the presence of Vaughn when he was young. So
Who took care of Vaughn?
he did, Ross did, the father did. First the mother did
from
when he
5
was
to
young, and then his beginning years, and then
She starts making tons of money.
Right, so
Dad
then
becomes,
he becomes basically a stay-at-home dad, taking him to all his games, his activities, his sports, whatever he was involved in. And I guess was very, went to school, went and talked to the teachers, made sure he was doing his homework. From that standpoint, if you didn't know any of the other facts, he would, sound like he was a very involved and caring parent. Like I said, not knowing anything else.
So now, how does the case get to court?
If I could just add
Yep.
one fact, he quit drinking in 1985.
Yeah.
Okay.
Yeah,
So they-
And attended
He
regular
goes to AA meetings weekly, and she cut down her drinking,
Okay.
Ted's Al-Anon, but Melissa
Okay.
can add whatever.
Oh,
Melissa?
no, I was just gonna say,
Mhm.
the court made a note of that, yes, he's taking on more and more responsibilities, but he was overly involved too, this kid's pushing 11 and they're showering together and giving each other massages, and he's kinda trying to buy his love,
Okay, now you
riding
said the court, how does
motorcycles.
this case get to, first of all, the probate and family court, and then ultimately the SJC?
In October 1st, 1992, Leslie filed with the district court to have Ross vacate the couple's home and surrender custody, and to remain away from the home and her.
Okay, that's the district court restraining order case. How does this case get to probate and family court?
Well, Ross then, Ross commenced an action to establish paternity, and then he wanted to obtain custody of Vaughn,
Right.
so they, basically the parties, basically the, I don't know if it was at this point that the Dr. Bruzesi.
I was just gonna ask, what are the professionals that were involved in the case, and what were the recommendations of the professionals?
So they,
Can I stop you when you say they, because I get very confused
Okay, I'm sorry,
when
the
people say
party,
they.
so the
Okay.
mother and father, Leslie and
Mm.
Ross, originally entered a temporary agreement that they were gonna have joint legal and physical custody. So they were basically splitting Vaughn's visitation, during the week, 1 week with him, 1 week with her, with Ross, 1 week with Leslie. And then during this, the father bought out the mother's share of the house, and then like the mother moved into a new home. And then like Leslie and Ross also agreed that, Dr. Abruzzi, or Abruzzesi, I'm not sure how to pronounce that, he should be appointed the guardian ad litem, who's a clinical psychologist, who they had previously consulted with, I think, I'm assuming about Vaughn. And they wanted him to make an evaluation and report, like, regarding custody of the child. So they wanted him to be like the impartial guardian ad litem and to say basically who should have custody, Ross or Leslie. And Dr. Abruzzi delivered the report and said that he recommended that joint custody should be continued, but that the Vaughn's primary home should be with the father, and then on weekends with his mother. And then Leslie and Ross went back into probate court, and they entered a new temporary order maintaining the legal joint custody, but giving Ross primary physical custody and visitation rights to Leslie. This was because of the doctor's recommendations. Then there was a 3-day trial in July of '93, and the probate court entered a supplementary judgment on September of '93, continuing this arrangement. And Leslie and Ross were to have joint legal custody with primary physical custody to Ross and secondary custody of the mother, the same agreement. And a visitation schedule was going to be set up for weekend, midweek, holiday visitations with Leslie. And she had to maintain his health benefits, his health insurance, and Ross had to pay $135 a week in child support. And then the court ordered them to remain in therapy for their own emotional issues. And to
When you
be
say
able-
the court, you're still talking about the trial court's decision, the
Yeah,
probate
this is
family
still
court?
probate court.
Okay.
So then, Leslie then files like appeal to the appeals court because she didn't like this arrangement, and which reversed the
Well, right,
judgment.
he got custody, he
Right.
had the kid, her
Right.
kid. Of
So
course she didn't like it.
Right, so she, I'm just stating facts.
You're trying to be impartial,
Didn't know
okay.
I was supposed to be, getting emotional about it. She was outraged, so she went to the appeals court, which reversed the judgment of the probate court for errors of law, and remanded the case to court
the
back
SJC?
no, they remanded the case back to the
You said
probate
she
court.
went to the appeals
She
court.
did, yeah.
How did the case get to the SJC?
I'm getting there.
Okay, all right, okay. Make sure we have the procedure correct.
Sure, so,
You guys want some tea?
yeah.
Maybe something, I don't know.
The appeals court, okay, we're done with that, I guess, so, because they gave reasons why it should be remanded to probate court and all that jazz.
Or reversed.
Yeah, but now she wants to know how it got to the SJC. Right.
Somebody didn't like that.
Someone didn't like what? You can
She
jump in
went on
anytime.
appeal.
Right.
Dad doesn't like that, he seeks further review,
Right,
and now tell me about the SJC.
well, when I believe.
What was wrong with the trial court's decision in this case? Why did this case basically make new law? I mean, it's every time you hear about domestic
Because they
violence,
didn't consider.
it's the Vaughn case.
Right, they didn't consider there was not enough proof.
Can you please not say they?
I'm sorry, the court, the.
Which court?
Trial court.
The trial judge, because that's only one person.
Okay.
All right.
The trial judge did not make enough findings regarding the evidence that the father had physically abused the mother.
Enough?
Or any
Any?
findings. And,
Why is that so important?
well, because then you're making a decision based on no evidence. I mean, how is that?
Why is that important in terms of domestic violence, when domestic violence is alleged, because there was a contested
Right.
trial?
Well, because then you're depriving somebody's due process rights,
Who's you?
not you, okay?
And
The
was this case about due process?
No,
No.
right, I know it's not about that, but I'm thinking that you're just gonna take,
Who's
the
you?
judge is going to just take allegations and make a decision based on no factual evidence, that's a problem in general.
Yeah.
So we had the GAL,
Yeah,
Yep.
who had no clue, but I'm sorry, but he didn't. He had no idea about domestic violence, but, you know, he was a respected, you know, in his field and so forth, who does an investigation and makes a recommendation as to custody. Then we had, you all mentioned the story, okay, the judge heard this story about, and the, you know, Leslie doesn't appear well. Let's put it that way, okay? She's, herself, even though she's tiny, physically abusive herself. She drinks, she's naked on the street one day, whatever. Somebody comment about that and how that intersects with battered woman syndrome.
And then there's a small factor there, that timeline-wise, in 1992, October, Mom filed a 209A abuse prevention order against her husband, and then in 93, they had the custody hearing. And my reading of the opinion, I don't think juvenile court took notice.
Probate court.
Probate court, sorry, took notice, the judge did not take notice of the 209A abuse prevention order when he awarded primary custody to the dad.
Well, that's partly it. Steve?
Are you trying to get to the gender bias study that the SJC did in 1989?
Partly, yes.
Okay, so
Yes.
in that particular study, obviously by the SJC, they said the appellate court did not put enough weight upon the abuse of the husband to the wife. And quoting them, they said, court should make it clear that abuse of any family member affects other family members and must be considered in determining the best interest of the child in connection with the order concerning custody. And so the SJC looked at it from that point of view and said that you didn't take any consideration on that abuse. I think that's where we're going.
Yeah,
now,
and
is that-
I'll come back to my question, my other question that I just asked, but you're right, and Kerry's correct too, when she said that the SGC holding has to do with before you make any custody orders, when there are children involved and when there are allegations of domestic violence. You've got to make findings. You have to back yourself up, basically, as the trial judge. I'm going to order custody to supposedly this abusive parent. I have to look at the implications on the child. What behavioral characteristics the child has, perhaps as a result of the domestic disturbances occurring in the house and so forth. So I've got it, and that then gets Paul mentioned earlier, codified in 208-31. Judges today, again, is there a 209A? I'm sorry. Are there allegations, of abuse in the household? Is it a contested custody situation where it looks like the abuser is looking for custody of the child? Let's look at how is the child doing? What characteristics does the child express? Do we need a GAL for the child to determine where the child is better off in terms of the best interest of the child? Now I mentioned characteristics. Let me go back to my earlier question when I said about Leslie and how she presented and how typically, and that does lead into the partly, as I said to you, Steve, the gender bias report. In those days, it was thought that mothers basically always would get custody of their kids. But in battered women syndrome situations, notice that Ross was the guy in control. They typically were more successful in getting custody of their children. Why? Well, this was a little bit different situation where Leslie had the better job and whatnot, but typically husband has is making the money, has the better job. Wife is as a result of being either physically, emotionally, etc., battered, is really a mess. Comes to court a mess, testifies a mess. Batterer looks comes in with his nice suit and maybe even his briefcase and his notes.
Prepared report.
Right?
His psychologist report nicely printed up. puts in front of the judge.
Exactly. And so that was the result of the gender bias study. Now, Brooke pointed out correctly that Leslie was looked at, well, you're just as abusive yourself. You have all these faults yourself, and
Not that I
what-
think, but not that I think
exactly.
that what he was doing was right, but I think that they both stunk as parents, you know what I mean?
Right, and why does she stink as a parent?
Well, one thing, she's allowing her child to be in that situation.
Okay, allowing the child to be in that situation. Again, let's try to get to the dynamics of a truly abusive situation.
She was abused as a child herself. Then she was allegedly abused by 2 ex-husbands. And then she has a pattern of abuse, clearly, from reading this. I mean, obviously, I don't know.
Sounds like she doesn't know how to break the pattern.
Well,
Yeah.
it's almost
Exactly.
like,
That's
it's almost
usually
like
the
a
circle,
comfort,
yeah.
it's not comfortable, but I meant, she's used to that, and I hate to say that, but, you know what I mean, like,
Yeah, she's a
that's
victim.
all
She's
she's
always been,
known,
yeah.
right? So her child being exposed to it, she was exposed to it when she was a child, it turns into when she's an
This whole
adult.
cycle,
And
yeah.
then, the cycle, so I feel like that has a lot to do with, to your question, like, why? Why is she allowing her child to be exposed to that? Cause I
Right.
think that anyone who's not in that situation would look at it and exactly ask that. Why would you allow your child to sit there and watch, someone beat the hell out of you?
Is anyone familiar with Dr. Lenore Walker's theories on the cycle of domestic violence?
It came up in
She's
Netflix.
like a classic candidate for battered women syndrome.
Who is?
Leslie.
Oh, yes, but
Yeah.
did you answer, you didn't answer my question.
Well, I'm sorry, I thought
I
that
said,
was
is
the
anyone
answer.
familiar with Dr. Lenore Walker?
Vaguely, I think
She's,
Professor
it's the
Capone
whole,
mentioned
the
it in
power
his
and
class.
control wheel, and I know you've seen these all over the place, right?
Yeah.
Dr. Lenore Walker, I don't even know if she's still living, but, her theory was that, in terms of a domestic, an abusive situation, control, as Brooke said, physical, emotional, sexual, etc. A building up of tension, and then some kind of incident. So in this case, maybe one specific incident would have been the incident where Leslie was taken out by an ambulance when he hurt her. And then what Dr. Walker calls the honeymoon period. I'm sorry, I'll give you roses, it's Valentine's Day, let's start afresh, I didn't mean to do that, let's go, And then a period where everything's kind of nice, and then again, the escalating tension and, another battering incident and so forth. And the more that this happens, it's like being in the, fighting a war, right? You disassociate, you, as a result, if you have children, perhaps neglect or maybe even abuse those children as well. It's documented now. You are familiar with the DSM, the Diagnostic and Statistical Manual of Psychological Disorders. When I started practicing, battered women syndrome wasn't included as one of the disorders. It is now. Walker's circular theory is perhaps the most popular. The GAL report that I gave you was a case where I actually was involved in. And it's funny because the one of the girls that was involved, I don't know if I gave you I gave you fictitious names. Well, the older girl, I forget what name I gave her, had a very interesting take on it. And I remember her saying to me, my dad's always in control. When he's not in control, he's out of control. And that was more like, not so much as that circular, it was more of this kind of straight line with, humps in it, right? Always in control. And he was typical of that person I just tried to describe, the father who makes who is in control of the whole household. He had a notebook where their chores were written down. Every moment of their day was accounted for. He dressed very well, very meticulous in terms of dressing, and the household was set up that way as well. Everything was neat and, in order and so forth. And the wife, or the ex-wife, the mother of his children, was very similar to Leslie. Looked like she was crazy, because of the years of, abuse that she had endured. And sometimes it's real easy to look at a person like that and not like them, right? No, you shouldn't get your kids, or you're just, get over it, clean up your act. This ties into the care and protection cases that we started talking about. Remember that when DCF gets involved, and they're gonna come in and do something about those children, right? And one of the first do-somethings is, hey, get that guy out. Well, that's easier said than done. Okay. Number one, that guy may be, financially tied to you. Number two, you may be so afraid to get the guy out, because typically if it is a physical abuse that's going on, the woman is in the most danger when she tries to leave. That's when they get killed. And so DCF saying, this isn't our service plan, you can get your kids back if you do this. On top of it, she's crazy. Battered women syndrome is a form of mental illness that takes years, if at all, to recover from. So 15 months later, if this case goes to trial, what is the likelihood that if you represent mom, that she's gonna get custody back of her kids? You all look so serious, oh my God.
Loss is intense.
Okay. Can I ask a question?
Yeah.
I don't know a lot about 209As, but I'm reading along, I took a walk on this one, because this makes no sense. I think the dad bought her out or something. And she filed, and then they settled it, and then they decided to hire a psychologist together to report on custody. to the court.
So 209A is the restraining order statute, which is both the probate and family court and the district court has jurisdiction of 209As. It's a very low threshold initially to get a restraining order. It's typically not very similar, but when we talked about the emergency hearing of the care and protection cases, when the social worker is appearing before the judge and signs an affidavit and says that, I just removed the children, we need to have custody because they're in danger of abuse and neglect. If you're appearing to get a restraining order, you have to fill out an affidavit, and basically you're convincing the judge, very low threshold, that I'm afraid of this person, right? And then you've got some facts in the affidavit. Then that person, because of due process, Carrie, right, has the right to come back, and I forget, is it 10 days later with the 209As? I believe it is. And have, a hearing on whether that restraining order gets extended or not. Again, typically in many domestic violence situations, I'm just gonna say the battered woman, because it goes the other way too, but I'm just gonna use that. The battered woman might get it initially and then might back off afterwards. So it gets, dismissed.
They just drop their charges?
Yeah, exactly, because, if no one's there for that second hearing,
They know
it's gonna, exactly. Now, it's different if, she's actually, if it's a true, assault and battery, a physical, where he also gets arrested. It's possible that, the police and the district attorney might end up criminally prosecuting him, and that's another case, right, an assault and battery case, whatever. But getting back to your question, so ultimately this then becomes a custody case. So they're not married, but, Ross is looking for custody. And that's how it ends up in the probate and family court with the battle over custody.
Right.
And on the facts, it looks great, you know, he's been the one, I think by the time the case goes to trial, is Ross Vaughn is about 10 or 11.
11.
And he has been basically the caretaker of this child, so he does have a lot of facts in his support. He goes to the games, he bathes him, et cetera, et cetera, et cetera. So, you know, it doesn't mean that he absolutely can't get custody, right? What's the SJC's real beef is about the judge below, the trial court judge, the probate court judge, really taking a good look at this case and on the effect that domestic violence might have on this child before awarding custody to the person that supposedly is, you know, the batterer. But another reason why it's so important, you know, notice when it's decided in the mid-90s, when domestic violence hadn't really come to the forefront, you know, it was, you know, under the rug, right?
When was that case that the woman had her, like, the man killed her, but he literally stopped
Yeah,
her
that
head
was it Judge King out of, I forgot his name, I used to know his name, out of.
He was on a restraining order.
Somerville, yeah. Well, look at the more recent one that
Remy
we
case?
have, you know,
Oh, yeah.
it's happening all the time.
Did she drop that restraining order though? That was the-
Exactly,
and
that's what
I
I'm
was just gonna say
saying,
when you
it's,
said that,
it's so typical of these
Yeah.
relationships.
She dropped the restraining order and he came to the
He came
house
back.
and he basically decapitated her.
And that's one of the reasons why these cases are doubly hard when, DCF, you know, gets involved. Because typically the battered mate usually doesn't wanna leave, no, can't, well, I don't wanna say doesn't, can't, psychologically, financially, whatever, leave the relationship. And Brooke, I know as a mother, is outraged, because when she said before, you made a statement before about,
I think I just.
sort of allowing, you know, treating your child that way as a result of you being abused is just, you made some
Allowing
kind of
that.
statement
I
before, I
said-
forget what it was you
I
said.
allowing
that they
to
both
go.
stayed.
You said what?
They both stayed.
Yeah,
But
there
it's
was
not
a
just that,
famous
it's
case
also,
out of
you
New
know,
York,
It's also the way, you know, she engaged in taunting, provocative, violent behavior towards him too. I just don't think it's fair to have, you know, just one way. Like, I just think men get abused as well. But is it part of battered
it's
women's?
absolutely possible that,
I'm not saying
it-
in this case, I'm just
it-
saying,
exactly, it is absolutely possible that the case could be reversed. You also have domestic violence with homosexual couples, you know, I mean, again, I say battered woman syndrome
Mhm.
because typically 90% or more of the cases are, you know, women that are being battered. We also had in the state of Massachusetts, and the legislature had since changed the statute, cases where women ended up, you know, killing their batterers and then going to jail and doing time, the Framingham Nine. The woman who had, you know, been prosecuted and couldn't use that defense. Now, and I don't know what, I used to know the cite to the statute, you can use that as a defense if you've killed, you know, your batterer, a self-defense defense, which, think of it, when you come to the point that you end up killing your batterer, it's not because you're in the middle of this fisticuff fight. It's usually when that person is like sleeping,
Yeah,
right?
just
So you have to somehow show that whole imminent harm thing. But it's because of the effects of the battered woman syndrome, you're always in danger, you know, of imminent harm, even when that person is sleeping. But it's a very difficult defense, yeah.
But you know, Paul number 3, if he was here, could probably attest to this, but it's like.
Paul number 3.
Yeah, just laughing. We're numbers.
Who's Paul number 3?
It's so much easier.
Yes, we
It's
are.
so much easier. It's like clockwork. But, you know, it starts before that. It's like you have this history of abuse with a lot of women or neglect, so they come up with such a poor sense of self-worth to begin with.
Exactly.
That when they find someone that's going to take care of them, then they allow them at all costs, okay, but there's a roof over my head, I can't leave him, what would I do without him, I'd never make it. And, you know, from a police standpoint, you know long before it gets to court that this is gonna happen. How many calls for domestic violence, and as soon as the woman finds out somebody's gotta go to jail, instead of, you know, her helping the cops break up the fight, she's hitting the cop over the head with a lampshade saying, don't touch him, leave him
Exactly.
alone, when she called the police and said, come get him, he's hurting me.
Now,
Happens all the
remember
time.
that battering occurs across all socioeconomic, whatever, regions, you know what I'm trying to say.
Yep.
However, you don't hear about, you know, the mates that are battered, that have some means of their own, are not gonna go and get that 209A. You know, they're gonna go to their other apartment, or you know, they can take care of themselves. Because they can take care of themselves financially, they're gonna hide it.
Yeah.
They're gonna hide it more.
They try to make a quiet exit.
Exactly.
Yeah.
I just have a question, and it probably goes into criminal law, but I don't understand why if the woman doesn't show up at trial, you know, it gets dismissed.
No, I'm not saying a trial, I'm talking about the 209A.
Yeah, but
Okay?
I
If he's being criminally prosecuted, the case can still go forward.
Because I was a witness
Yes.
to domestic violence, and the girl was only 16 and the guy was 19, and they just dropped it when she didn't show up. I just
Oh.
thought it was awful. She was a child, you know
Yeah,
what I mean?
how long ago?
Last year,
Oh, really?
around this time. It was in Lawrence.
Oh, that's very interesting.
Yeah, I
Yeah,
thought that
yeah.
someone should go forward, you know, where it's a child too.
Yeah, I would think so too. I
But
agree
they
with
just
you.
seem to, no,
Mhm.
well, it's out of our hands.
Protection order against, from the child?
No,
Who's
The
your
criminal, it sounds like Brooke is talking about a criminal trial.
Oh.
Yeah.
Oh.
Yeah, yeah. And so, again, you know, there's issues of, am I gonna be able to sustain my burden of proof? Is it worth going forward, et cetera, that would, you know, prosecutor would have to think about, do I have a triable case?
Yeah.
Perhaps that, it was related, you know, to that, but certainly the police could go forward,
Well, they
you know,
went
with
forward
a-
with it, even though she said nothing happened.
Mhm.
She had a bite on her and she looked beat up, but she said nothing happened, but I said I saw the whole thing, you know?
Yeah, yeah.
So they arrested her.
Yeah, so they had a witness, they had maybe photographs or whatever, so
But
there
it's
would have
even,
been
it
enough.
was horrible for me because these are like neighbors and they lived a little bit down the street and my name's on the list. So then she came up, please don't press charges against me.
Oh, no,
I mean, it was
that
really
must
like
have
a
been
crazy
very,
situation.
yeah, very odd.
And I hate to give the like, this is what happened in my life story, but it was just crazy. I mean, I couldn't, they don't protect a witness at all.
No.
No.
You're on your own, you know, unless you're in one of those high-profile, right,
Right.
cases. Now, did you all read the GAL report? Okay, so, it was a very interesting case because there wasn't a lot of, you know, physical battering. And it took a long time really to determine that the children were not that well off, you know, being in the custody of their father rather than their mother. And it was interesting to look at the two children who were only, I think they were about 3 years apart.
13 and 8,
13
5
and
years
8,
apart.
yeah.
How old were they at the time?
13 and 8.
They were 5 years
At the lawsuit
apart.
time, I think, maybe younger.
Where there was an observable difference in both the behavior and the characteristics of the two children. And so children that witness abuse, as we mentioned at the beginning of class, there are direct effects of that. And what do children do? They, you know, they imitate their parents for the most part. So it turned out really that one imitated the father and the other kind of imitated the mom, you know. The younger one wanted to please, she was, you know, pretty and cute and no one got mad at her. The older one was just, you know, kind of also out of control and stubborn and changed her mind back and forth and was just very, you know, I don't want to say abusive, but, you know, it imitated in many ways the narcissistic behavior. characteristics rather, of the dad.
The mother, can I ask a kind of a dumb question? I should know if I read anything over again, but the mother lived in Florida?
Well,
and the
I mean,
father
there
lived in
was,
Massachusetts?
as with many cases, they're never like this simple one-issue thing, right? They were divorced, then she wants to get married again. They were divorced, and in Massachusetts, if you had children, they're still within the jurisdiction of the state. So if one parent, you know, who has custody typically, wants to move with new husband or new wife, or just got a new job, got a job in another state, unless the other parent agrees, right, you have to get permission of the court. So that was one issue, and you know, father didn't want that to happen. And then there were all kinds of other crazy things. He ended up, father ends up with another girlfriend, and this is much later on. Well, it turns out that he's abusive to the girlfriend too, and the girlfriend's child as well. And so, you know, sometimes just the passage of time changes the direction of cases. What's very interesting about this case, and I think from when maybe not when I first started teaching this, but at some point I decided to put this GAL report in there, because it had such a profound effect on me, on just the dynamics of domestic violence when it's not that clear. About a year ago, the older girl reached out to me, and she's now has kids of her own. And you know, you have all kinds of cases as a lawyer. Not that you don't think anything of it, but you know, you remember the cases and whatnot, and you remember the people. And she said something very interesting. She said, my sister and I, and I don't think I was that great, so don't, you know, my sister and I talk about you, you know, often, and you were like the only person that was on our side during all of this. And you forget about them when kids get embroiled in this stuff. There's the judge, there's the probation officer, if DCF is involved, there's a social worker, there's a, you know, attorney for mom, attorney for dad, mom is saying this, dad is saying this. And they feel very much guilty too about, you know, even indicating a preference, or guilty about divulging, you know, abuse or neglect. And it was just very, I was so glad to hear that she said, you know, we had no one. Even though they had mother, father, their aunts, they had grandparents on both sides, they felt like that nobody was really hearing, or, you know, was really their voice. And not that I was their voice so much, because, you know, guardian ad litem is different from children's attorney. It was a very,
Oh, right. Yeah, it doesn't
interesting.
have to be a lawyer.
Exactly.
I get that confused. Can I ask you a question? I got the impression in this letter that, was it the paternal uncle and aunt that they were living in, and then and the maternal, the aunts and uncles got in a fight too, didn't they?
Everyone got in the fight, as you say, got in the fight, yeah. And took one side or another, or was changing sides depending on the circumstances. Oh, they wanna go to Florida, why do they wanna go to Florida? They shouldn't go, you know, there. Oh, she's marrying this new guy, he's, you know, this and that. Exactly. But if you have any, indication whether you're practicing in like a divorce area, it's 208-31. If it looks like, you know, there's domestic violence or even allegations of it, and the judge is going to be deciding custody, you've got to look at 208-31. You've got to be in compliance with bond, you know, and the judge has to make, you know, specific findings about, you know, ordering custody to someone who allegedly is a batterer. Paul, you just had your hand up too.
Yeah, I was wondering, you said the maternal aunt has a pending TRO, it didn't say TRO on the defendant, that's due out on October 15th, and this was like dated October 1st. Were you kind of like did you put that in the report, just to take notice of the fact that there's a restraining order out there
Yeah,
because of this
Yeah.
statute,
Yeah.
you have to bring that up.
yeah, yeah, exactly. So again, in taking it back to the care and protection cases, that's what you're gonna get, you know, you get a court appointment for mom, say, and it's a domestic abuse situation. You're typically gonna have, you know, DCF wanting her to have the bio dad out of the picture. And again, that's tough. Not only tough, but in terms of time, if this case truly goes to trial with, remember the care and protection cases, by statute, 11926, they have to go to trial within 15 months. So somebody is screwed up as Leslie, for example, is that person, you know, through therapy or whatever, going to have her act together in 15 months when you go to trial, and the issue is current parental fitness. DCF is likely to meet its burden of clear and convincing evidence of unfitness at trial, even if mother has taken some steps, you know? So they truly can be sad, tragic cases, especially when, you know, the parents haven't directly, you know, abused or neglected the kids, but it's the parents' behavior that has a profound effect on kids, and then those kids become adults and so forth, right? And we have the whole cycle of abuse. Now you'll find when we, I don't know if you'll find this, but we start child sexual abuse, and sometimes there's a direct sort of correlation, I hate to say, with DV, domestic violence, and child sexual abuse. Child sexual abuse, when it's family abuse, right? Familiar. It's tied in to that issue of control, right? So you typically have, when there are allegations of child sexual abuse, you know, stepfather has raped his, you know, stepdaughter, or even father, you know, or mother, etc. You'll find that there's also issues of domestic violence in the household as well. I've given you cases for Thursday on child sexual abuse, and I think, and I don't have the syllabus in front of me, but there's a very important statute that's not in the reading until next week, and that's chapter 233, section
Is it 81?
81, 82, and 83.
Yeah, that's in the case for
It's in the
this
case.
week also.
It's in the cases as well, so I don't know if you'll be confused because you'll be reading the cases without the statute, but basically it's adequate statements of children under 10 alleging sexual abuse are, with certain provisions, admissible in criminal, civil, and care and protection cases. Obviously, in the criminal cases, it's much more difficult to get them in. And you can look at, so section 81 is much, you know, the longest section, it's the criminal section. 82 is for civil cases, so typically if it's in probate and family court, for example, and it's a termination case or a divorce case, 82 applies, and lastly, 83 applies to the care and protection cases. So with that last one, with care and protection cases, is much easier to get in the adequate statements of children under 10. I'm gonna try to give you the case study by Thursday, so that we can discuss some of the issues, which are mostly evidentiary issues, you know, dealing again with, you know, with hearsay. They also go into, you know, role of counsel, father's counsel in a sexual abuse case, father's counsel that represents the father both in the criminal case and the care and protection case, and kind of the sequence of those two cases going on at the same time. Children's counsel, what children are alleging that it didn't happen, and they want to stay with the father. burden of proof issues relative to the department. What does the department have proof of the sexual abuse? Typically in these cases, the only people that really know what happened is the batterer, the perpetrator, and the child, unless there's some physical, evidence, for example, rape, etc. So it's a case study that parallels a lot of the cases that you will be reading. So again, you'll be reading not only that statute, but criminal cases, as well as care and protection cases, as well as termination cases. So we started that on Thursday and go into that like all next week. Any questions about the process? Because I notice I still have my notes on the board when I described the care and protection process. Paul?
I'm just asking too many questions today.
No, that's all right.
Is there any abuse of the restraining order? People sometimes file it on purpose, just knowing.
Yeah,
that they go to
I have a
custody.
funny, awful story from when I started practicing, and I didn't know what I was doing, and this was before 20831 and Vaughn. So my boss, who was just a typical happy-go-lucky Irishman, sends me down to district court to get a restraining order with his client. What I didn't know was, as she goes up to the desk, she says, and I'm the lawyer, but she was talking about Dan, the boss lawyer, somehow blurts out, my lawyer said to do this so I can go to probate court and get my divorce afterwards. And I wanted to just crawl under something at the time. So yes, it was said that there was abuse of 209, of that process on the one hand. On the other hand, you have the cases like Remy and other cases where judges and court personnel have really failed to recognize a domestic situation and have been outright mean and nasty, right, to people that are trying to seek aid or trying to inform the court of domestic violence issue. So yes and no to your question.
No, the judge could probably see it for what it is. They see so many cases.
Well, judges, just like us lawyers, have to, be trained, and it's not just being trained in legal, it's psychology, it's biology, it's sociology, etc., right?
Yeah.
It's child development.
But that used to be very common about women who would go to criminal court and
Exactly.
press an A and B, and then be in probate court and say, well, he currently has an assault battery charge pending against him right now.
Yeah.
Yeah. Oh, I see.
Yeah.
And then they never show up for the A and B, and that would be, dismissed with prejudice, so be done,
Yeah.
but that was very common, especially back in the '70s and everything else.
Yep, exactly.
I'm not implying that that's the right thing to do, or the wrong thing to do. The law is good, that's what I'm gonna say. It needs to be this way.
And because some people did that, right, it was really hard on when it really happened to
Yeah.
others,
Correct. That was like crying wolf time.
Exactly.
Just got to be pointed at.
It's a bad thing to do, it's a malicious prosecution.
Yeah, but at the time, people, I know people went through that and everything, and there were lawyers that actually specialized in that, out of Lowell and everything else. There was a couple of them since dead, but they used to say, no, the first thing I do is file an assault battery, that's it.
Yep.
Because it was always cruel and abusive treatment, those were
Right.
always grounds.
grounds for
Right,
divorce,
no fault.
exactly.
Oh.
And so then when you went and filed your divorce, well, I've got this restraining order out of the district court because he's abused me, he
So
hit me.
he'd be up on Gorham Street.
So it became-
And then he'd be down on Hurd Street, and he'd be going back
Steve,
and forth between
yeah,
the two.
Steve remembers the deal. Mhm.
Well, that's because you have to have cause for divorce.
Yeah, well, you didn't have to have cause, but it
You could,
the
there was no
easiest way,
irreconcilable,
the best grounds were cruel and abusive treatment.
irreconcilable difference.
Yeah, there was no no-fault divorce back then.
Yeah, no fault divorce.
Exactly, so now yeah. All right, well, I'll see you Thursday.
Okay.
Way finished earlier today.
Excellent.
Okay,
I did
all
think
right,
so too.
thank you.